The next case on this morning's docket, that is case number 108206 in the matter of Douglas Lee Baker.
May it please the Court, I'm Alexander M. Walczak, Deputy Disciplinary Administrator. Mr. Chief Justice, with the Court's permission, I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Briefly, the background for this attorney disciplinary case against Mr. Baker was two state of Idaho District Court judgments and in the state of Washington Securities Agency order reflecting that Mr. Baker committed securities fraud in a mining venture wherein he raised $2.7 million and immediately upon receipt converted the funds. On March 28, 2012, a panel hearing was held. The respondent stipulated to the factual allegations in the former complaint as well as that his conduct violated 3 ethical rules, 4.1, 8.4c, and 8.4g. Real briefly, the first Idaho judgment was against a company he formed. It was an Arizona-Idaho mining company. The judgment was for $1.7 million. Mr. Baker was the managing member of this LLC. The second Idaho judgment was where the court imposed a judgment of $2.9 million, which included $360,000 worth of penalties. The Idaho court found that Mr. Baker committed securities fraud when he made 4 material misrepresentations.
And those material representations were made to induce people to invest, isn't that right? That's the purpose of those material misrepresentations.
That was the interpretation of the Idaho District Court.
Do you have a different interpretation on what he was doing?
No, Your Honor.
I guess what I'm getting to, Mr. Walczak, is why, when I read the disbarment criteria, a lawyer who engages in intentional conduct involving dishonesty, fraud, deceit, or misrepresentation that seriously adversely reflects on a lawyer's fitness to practice law, why aren't you talking about that?
Talking about disbarment, Your Honor?
In this case?
The reason is I was very uncomfortable as to what was the appropriate discipline to recommend at the panel hearing. I did recommend suspension for a period of 2 years, which is what the court had.
2-year suspension for stealing $2.3 million?
The reason for that is because I had a prior experience where I was the disciplinary administrator on a very similar case involving in the matter of Fred Rausch, in which the panel in this court imposed a 2-year suspension. And I know comparing cases is not appropriate, but in my mind and under the facts, I did compare the cases, and that was the reason, as well as when I took this case to a panel hearing, which was in 2012, the Idaho judgments were 2005 and 2006, respectively. For those reasons, but I agree with Your Honor that this court can easily find that the appropriate discipline in this case is disbarment.
Well, let's look at it from the standpoint of the public. What will the 2-year suspension do to help protect the public against dishonest conduct by a practicing attorney in this case? How's the 2-year suspension going to fix the problem, is my question.
Well, it won't unless the suspension, Your Honor, is such a deterrent which would cause Mr. Baker to comport his conduct where you would never commit this type of, again, but you're right. On review before this court, the respondent filed exceptions, but the exceptions was only as to the discipline recommended by the panel hearing. Again, the panel recommended 2-year suspension. Prior to the announcement of the panel's disposition, Mr. Baker submitted a proposed plan of probation. I opposed it. I do not believe it's workable, practical, detail, or addresses the misconduct in this case. The exceptions that Mr. Baker filed in this case was that the panel erred in not recommending to you that his plan of probation be approved. My recommendation is to affirm the findings, conclusions of law, and appropriate discipline. What I recommended at the paneling hearing was 2 years suspension.
And is that your recommendation today, or have you moved off that position?
I believe I've moved off of that position, Your Honor, to disbarment.
Right. Any further questions of counsel? Any further presentation?
I have none.
Thank you, counsel.
Mr. Chief Justice, members of the court, Joseph R. Colantono appearing for Mr. Baker. My remarks will be fairly brief, and then I will defer to Mr. Baker. Mr. Baker has provided service to the state of Kansas. He was a state legislator for 4 years, Crawford County Attorney for 2 years, Frontenac City Attorney for 6 years, an Assistant Cherokee County Attorney. He has been an active member in his church. He had an illustrious career until he got sidetracked with the thought that he could prosper and do well with this mine that he organized the development of, that he worked on site for a number of years. There's no misunderstanding on his part. He made very poor judgments. He should have never abandoned the promising career that he had. There's no risk of recurrence in regard to whether a 2-year suspension with probation would be adequate, an adequate deterrent. There's no risk of recurrence. This circumstance he finds himself in resulted from his effort to develop an investment plan, this mining opportunity. He's returned to the practice of law. His practice is developing, and he hopes that this court provides him with a second chance, with the opportunity to grow that practice.
I guess I don't understand what you just said, that there's no risk of recurrence because he just had this one investment opportunity and now he's practicing law. I mean, in my experience in practicing law, there are numbers of investment opportunities that get presented to you over the course of any kind of business practice or any kind of civil practice for sure. Clients come to you, you see deals, you see a building next door. So explain that to me more.
I have a two-pronged answer. Number one, based upon the attention and public visibility of this, people don't come to him with investment opportunities. It just doesn't happen now.
Because they don't trust him?
I think it's the same as anybody who, in this day and age, does research over the internet as to who they want to be in business with, who they want to invest with. So the opportunities don't come to him, point number one. Point number two, he is not searching them out. He's committed to his practice, which is limited to plaintiff's personal injury practice, which has that narrow focus.
And what's the guarantee that the Nix Gold Mine isn't the whiplash injury case that's studied in his office? That he sees that as the way to make the money?
Your Honor, the best response that I can give you is that this has been devastating. It's ruined his life financially. It's sidetracked a promising career. And I think as the court listens to him, I think the court will get a better feel as to why there really is no risk of recurrence of him getting sidetracked again.
Do we have any more questions of council?
Well, I just want to clarify, this was a fairly sophisticated, carefully orchestrated scheme that was set up. He utilized his legal skills to set up these corporations because he couldn't have done it without being a lawyer. And that is all true, and then induced numerous people to invest millions of dollars in this scheme and converted that money for his personal use. That's all true.
Correct. If I could say there's two aspects to that. One, inducing investors. Two, what was done with the money afterwards. And I think Mr. Baker will be able to explain and hopefully satisfy the court that when investors were attracted, he genuinely had the belief that this venture was going to be successful. He believed. I understand that doesn't answer the question about what happened to the money afterwards.
Well, yeah, but the reason, the basis on which he induced the investments was assurances that the money would be safe, which weren't true assurances.
I recognize that.
Counsel, when we've dealt with some issues with other lawyers in the past, examples of people who say they've suffered from depression, that's what led them to their improper conduct, or they have a substance abuse problem, or they have some other explanation. And then oftentimes in those situations, they present us with a report from their counselor, from a social worker, from a physician, explaining this was an aberration, it's never going to happen again. Is there anything like that that we can rely upon other than what you've told us today?
We cannot point to and are not relying on any substance abuse issue. There was not one. We are not relying on or attempting to point to depression or some mental impairment. He simply lost his perspective and made very bad judgments. When Your Honor refers to other cases, I might reiterate the reference that Mr. Walczak made to in Ray Rausch. I think when you look at the basic circumstances of both situations, and if we're looking at some level of consistency, I do believe that a 2-year suspension with probation is appropriate in Mr. Baker's instant when we look at those two.
In light of what you've told us, then, we should be confident that this situation will not recur because we have your client's assurance that it will not recur.
Correct, and I believe that you will hear that shortly when I defer to him and he completes the argument.
All right, thank you. Any further questions? Any further presentation? Thank you.
May it please the court, Mr. Chief Justice. My name is Douglas Baker. I am the respondent. 37 years ago, I first appeared before this body as a newly minted lawyer representing Cherokee County. I had no concept that I would ever appear before this body again under these circumstances. And I can assure you the event which triggered my appearance here today will never happen again, as you will note. 12 years ago, I wrote a private placement memorandum for a gold mining venture. It was a gold mining venture that I had been involved in at that point in time for 9 years. I was also the senior partner in 2001 when I wrote the private placement memorandum for Baker Houst. It was a plaintiff personal injury law firm in Boise, Idaho. I represented approximately 150 personal injury clients on an annual basis. Those clients had all been referred to me by doctors. I've never advertised. I never intend to advertise. Maybe some of you knew Professor Folks from Washburn Law School, and when it first became ethical to advertise, he told me that even lawyers have a First Amendment right to make a fool of themselves. Well, I have made a fool of myself in this case, and that happened in the litigation in the state of Idaho when I determined to represent myself. The old adage, he who represents himself represents a fool, was never more true than in that case. When the state of Idaho filed a lawsuit, I hired the best securities lawyers I could find, and I frankly ran out of money and ended up representing myself. So to answer the question that you posed about taking all the money, of the $2.7 million that was raised, the bulk of that money went into the mining project in Arizona and Idaho. The money that I was paid was a reimbursement of the money that I had spent in 9 years working on those claims. I own 90% of those mining claims for 9 years. And when I formed Arizona Idaho Mining, I transferred my entire interest into the company in return for 10% ownership and a reimbursement of my money.
Sir, are you saying that that was reimbursement for work you had performed before the formation of this venture?
For work I had performed and for money I had invested.
Prior to the involvement of the investors?
Excuse me?
Money, you're saying the money went to pay you for work you had done prior to the involvement of the investors?
That's correct.
Okay, thank you.
And a reimbursement for the actual money that I had spent. I spent my entire life savings buying equipment, hiring people, putting that venture together, over $450,000. Even after the lawsuit was filed, I spent another $200,000 of my own money trying to keep the thing afloat. When the lawsuit was first filed, an investigator for the state of Idaho told me that they knew it was a scam, that I was simply trying to bilk people out of their money. They didn't look at the hours of videotape or all the information. I gave them 3 boxes of information that had been accumulated over the 9 years that I worked on that project. But that was their attitude, and they tried to make the facts fit that assumption. The petitioner has stated that I knowingly misled investors. You have to consider who those investors were. My brother invested, my cousin was an investor, my personal physician, my dentist, my accountant, my law partner, other lawyers that I dealt with, my pastor from the church in Idaho, people from my church in Idaho, business associates in Kansas and Idaho. Would I willingly and knowingly mislead them or make statements to defraud somebody like that? No. I worked on that mine in Idaho for 9 years, and I am convinced to this day that there's still gold there. It was only in 2010 that I gave it up. Now, I have developed over the years an expertise in whiplash injuries and mild traumatic brain injuries. I'm the only lawyer in the state of Kansas that's been certified by the Brain Injury Association of America as a brain injury specialist. 3 years ago, when everything else had failed in terms of trying to do other entrepreneurial ventures, I began to reconstruct the practice of law. Over the past 3 years, I've developed relationships with doctors and healthcare professionals that are now referring personal injury clients to me. Today, I have 40 clients. I'm on my way back to helping people that have been injured. Most of my clients have been denied their claim by the insurance industry because that industry knows how difficult it is to prove soft tissue cases and mild traumatic brain injury cases. No clients invested money in Arizona Idaho Mining. No clients lost any money in this venture. If there was a misstep on my part, it was not in the practice of law per se. I have no prior disciplinary complaints. The Kansas Securities Commissioner investigated this and saw no reason to proceed. For 30 years, my wife has wanted me to be just a lawyer. And I was never content with that. I was never content to be confined to an office. And I did entrepreneurial things. And now my wife and I are on the same page. I just want to be a lawyer. I just want to represent my clients. This court in 1992, in the matter of In re Kirshner, considered the disciplinary's request that Mr. Kirshner be disbarred. He had 4 felony convictions for securities fraud. 5 years he failed to register with the court. He did not cooperate in the investigation. This court gave Mr. Kirshner a public censure. I have no convictions, misdemeanor or felony. I cooperated fully with the disciplinary administrator. I self-reported the judgment after it happened. I'm current on all my CLE requirements. In fact, last year I had an excessive number of ethics classes. I submitted a plan of probation. I've complied with that as noted by the affidavit filed. I just want to represent my clients and help them.
Counsel, the submission of the plan of probation, when did that happen? Was the statement that it happened between the panel hearing and the release of the panel report? Is that when it was first submitted?
It was submitted, I believe, in February. The hearing panel met in March.
Okay, thank you.
And your counsel a few minutes ago made reference to you made some poor judgments. Can you list for me what those are?
Well, my wife has called it the wretched gold mine since 1992 when I first started on it. So that would be the first poor judgment I made. The second poor judgment was not being able to see fully the writing on the wall that I was always going to be fighting with the government on any type of mining venture in the state of Idaho in a federal forest. And the third poor judgment was not having securities attorneys review the private placement memorandum before it was submitted. I lost that lawsuit on a summary judgment motion because of how the definition of a material fact was interpreted by the court.
Anything else on the list?
You know, I should have stayed with being just a lawyer. That was a huge mistake.
Well, you had made reference earlier, I believe, also to the fact that you should have not represented yourself, and that contributed to your getting into trouble. Is that correct?
That is correct, Judge.
Okay.
I was treated contemptuously. I was treated with no respect. It was something that I was not accustomed to. When I went to the state of Idaho in 1996, and I moved there with my family, I took with me letters of recommendation and letters of reference from Joan Finney, the former governor of this state, from Carlos Stovall, the then Kansas Attorney General, from Kathleen Sebelius, the then Kansas Commissioner of Insurance and later the governor, from Marvin Barkas, the former Speaker of the House, from James Concannon, the Dean of the Law School, from Tim Brazel, a district judge, and from Don Allegrucci, who is then a sitting judge on this court. And the common theme of all those letters of recommendation and letters of introduction was my integrity, my trustworthiness, and my abilities. So when I was a defendant in a civil litigation, it was a completely new experience for me, and I did not respond emotionally very well.
Mr. Chief Justice, if I might offer one comment in response to your question, his bad judgments and mistakes. I think it goes without saying, and I think that it's recognized in our filings, that making comments that have now been questioned and shown to be inaccurate was clearly a mistake. Pulling money out, as he did, was clearly a mistake. And that's recognized. I think those are two items that maybe I shouldn't say goes without saying, but it's clear to Mr. Baker, and there's no denying that.
Very well. Any other response to my question from either of you, gentlemen?
Well, there's just one, and that is in the private placement memorandum, it said that there were a number of interest owners, in addition to myself, that would be paid for their interest, and that the amount paid would be up to $1 million. And there was not specifically said who would get how much money. If I could do that all over again, I would say, I'm going to get this much money because that's how much money I've invested in the project. I'm getting a reimbursement of that.
In other words, the memorandum didn't inform your investors that you were going to be paid for work that had already been performed.
No, it did inform that I was going to be paid up to $1 million, along with Bill and Marie Strickland and other investors or other owners of that other 10%. At the time the private placement memorandum was written, I did not know if those other owners of the 10% were going to sell their interest or not. The offer was made, you can have the money or you can transfer your interest for a return in the bigger project.
But if I recall, the memorandum represented that they were going to sell.
It recommended that, yes.
Even though you did not know that.
I did not know if they would sell or how much money it would take to buy them out. In the end, none of them sold. They all transferred their interest. And I was reimbursed the $650,000 that was spent on the claims.
Any further questions of either of these gentlemen? Any further presentation?
No.
Thank you.
Reserve 3 minutes for rebuttal.
Members of the court, I want to address one question posed by Justice Breyer, and that was concerning the submission of the respondent's plan of probation. Prior to the panel hearing, the commencement of the hearing, Mr. Baker did submit a plan of probation. However, during the panel hearing, based on questioning of his proposed attorney to do the supervising for the probation and other questions of the moral compass supervisor, the respondent at the panel hearing made oral amendments, and then what you have before you in the respondent's brief is an amended plan of probation.
Okay. Thank you.
I have nothing further unless there's questions of the court.
Any further questions of counsel? Thank you, counsel.
Thank you.
Thank all of you for your arguments this morning. Court will take this matter under advisement.